Hello, everyone, and welcome back to Daily Dollars. Today, we're diving into a high stakes legal battle that's making waves all the way to the United States Supreme Court. At the center of this showdown is the Trump administration, which is urgently petitioning the court to overturn a lower court ruling that blocks the Department of Government Efficiency from gaining unrestricted access to the Social Security Administration's extensive database of personal information. This case is about much more than data access. It strikes at the intersection of executive authority, individual privacy rights, federal oversight, and the evolving role of technology in public governance. As the May 12 deadline looms, the Supreme Court is being asked to weigh in on a decision that could have far-reaching consequences for how public institutions manage sensitive data. In this episode, we'll explore what's at stake, the competing arguments from both sides, and how the outcome could impact not just policymakers, but millions of Americans whose personal information is held by the government. Before we break down the details, make sure to like and share this video and hit that subscribe button so you don't miss out on future updates about this case and more on Social Security. Let's jump in and unpack this legal clash. Let's understand the core issue here. DOGE, or the Department of Government Efficiency, is a task force created with the stated purpose of improving operational efficiency across federal programs. Its focus includes identifying waste, fraud, and administrative overlap in large-scale entitlement systems such as Social Security, Medicare, Medicaid, and disability programs. To achieve this, DOGE requested full access to the internal data systems of SSA. The agency contends that comprehensive access is necessary to identify patterns of fraud and inefficiency at scale. This includes not only anonymized data, but also personally identifiable information like names, social security numbers, health records, and financial details. According to supporters of this task force, this level of access is essential for understanding the root causes of system misuse and for developing algorithms that can better detect fraud before benefits are improperly distributed. They argue that targeted, data-driven reform could save taxpayers billions of dollars and help protect the long-term viability of public assistance programs. However, the request triggered immediate concern among civil rights groups, privacy advocates, and former SSA officials. A coalition of these groups filed a lawsuit in federal court, arguing that the data the Department of Government Efficiency seeks is protected under existing privacy laws and that granting such access could erode long-standing safeguards. The case was reviewed by Judge Ellen Hollander in the United States District Court for Maryland, who issued a temporary injunction. In her decision, she ruled that DOGE could continue analyzing de-identified aggregated data, but was barred from accessing information that could be used to identify individuals. Her opinion characterized the request as overly broad and lacking the legal precision required for handling such sensitive material. Judge Hollander emphasized that while the agency's goals may be legitimate, they did not justify circumventing statutes designed to protect personal information. She described the access request as a fishing expedition and noted the importance of upholding clear boundaries when it comes to data governance. The Trump administration responded with an emergency appeal, asking the United States Supreme Court to overturn the injunction. In a filing submitted by Solicitor General John Sauer, the administration argued that the Department of Government Efficiency's efforts are lawful and urgently needed. The appeal warned that if DOGE is denied access to detailed records, its operations would be significantly impaired, potentially halting efforts to uncover fraudulent activity. According to the administration's legal team, the lower court's decision represents an overextension of judicial authority into the executive branch. They argue that the executive has the right to organize and empower internal departments to improve efficiency, particularly when those efforts are aimed at reducing taxpayer costs. The administration is urging the court to act before May 12, a date it says is critical to the Department of Government Efficiency's ongoing data review cycle. If no decision is made, DOGE may be forced to suspend several of its current projects, including automated audits and predictive fraud detection programs. In opposition to the administration's appeal, several prominent organizations, including the ACLU, the Center for Democracy and Technology, and labor unions representing SSA employees, have voiced their concerns. They believe that this access of the DOGE would effectively open the door to surveillance and reduce accountability. These groups argue that allowing an administrative task force to bypass traditional agency review processes and access protected data risks undermining established norms around privacy and data handling. The senior policy director of the Center for Democracy and Technology, Elizabeth Laird, warned that such access could normalize mass surveillance under the pretense of modernization. She emphasized that once these boundaries are crossed, they are difficult to reestablish. Their position is that any modernization efforts should come with equally strong accountability mechanisms, and that no initiative, regardless of its intentions, should override constitutional protections without explicit legislative approval. As expected, the case has become a flashpoint in broader partisan debates about the role of government, data privacy, and the modernization of public systems. Republican lawmakers, including Senator Josh Hawley and Representative Marjorie Taylor Greene, have voiced strong support for the Department of Government Efficiency. They point to early reports from the task force that suggest over 10 million potentially fraudulent claims were flagged through automated review processes. Supporters argue that if DOGE is successful in identifying such cases, it validates the need for deep data access and a modernized approach to oversight. On the other hand, Democratic legislators like Representative John Larson, a senior member of the House Subcommittee on Social Security, have condemned the administration's approach. Larson has characterized the efforts as an attempt to centralize control, diminish public transparency, and circumvent constitutional checks and balances. He has urged Congress to reassert its role in regulating how personal data is used by executive agencies. While the immediate conflict centers on DOGE and the SSA, the larger implications of this case stretch across multiple dimensions of governance. It raises fundamental questions about the acceptable limits of data use in public administration and the evolving relationship between technology and civil liberties. Should innovation and fraud prevention allow for the reinterpretation of existing laws? Or should those laws remain firm to prevent potential abuses of power in the digital age? As more government agencies incorporate artificial intelligence, machine learning, and large-scale analytics into their daily operations, this case may serve as a blueprint or a cautionary tale for how data-driven governance is regulated going forward. With the May 12 deadline fast approaching, the Supreme Court is under pressure to make a decision that will shape both the legal and operational landscape for federal agencies. A ruling in favor of the administration could expand the scope of executive authority in data management. A decision upholding the lower court could reinforce judicial oversight as a crucial check on how sensitive information is accessed and used. Legal analysts believe the court's decision could set a landmark precedent not just for future Republican administrations, but for any executive branch seeking to streamline operations through enhanced data access. At its core, this case is about trust, governance, and the evolving nature of public accountability in a digital world. Whether one sees DOGE as a bold step toward a smarter government or a potential overreach of power, the questions raised here are significant and long overdue. What's your perspective? Should efficiency and fraud prevention justify deeper government access to personal data? Or is this a moment to reassert the primacy of individual privacy and judicial oversight? Share your thoughts in the comments below. And don't forget to give this video a thumbs up, subscribe to Daily Dollars, and turn on notifications so you never miss an update. Thanks for watching. I will see you in the next video.